Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce laws, court procedures, and filing requirements vary significantly by jurisdiction and are subject to change. The content shared here is based on historical trends and general case studies and may not apply to your specific situation. We are not attorneys, and this video does not create an attorney-client relationship. You should conduct your own due diligence and consult with a qualified legal professional licensed in your state, that be Washington, Oregon, or Idaho, before making any decisions that could affect your legal rights, assets, or family structure. Imagine standing on the deck of a ferry in the Puget Sound or walking through the rain-soaked streets of Portland, believing your life is settled, only to realize that the very ground beneath your feet is about to shift. In the Pacific Northwest, a divorce isn't just a signature on a piece of paper. It is a high-stakes chess match played out against a backdrop of community property laws and complex residency requirements that can trap the unwary for years. There is a silent crisis happening across the I-5 corridor where couples are losing $30,000, $40,000, or even $50,000 in legal fees not because their cases are complicated, but because they fell into the procedural traps of the Northwest court systems. What if I told you that the traditional path, the one where you retain an aggressive litigator and prepare for a courtroom battle, is often the fastest way to lose your equity, your sanity, and your future stability? We are seeing a massive shift in how people handle dissolution in this region, moving away from the adversarial model and toward a streamlined, document-centric approach known as the 661 method. This isn't about cutting corners. It's about understanding the specific mechanics of PNW law to avoid the catastrophic financial drain that most people consider an inevitable part of the process. Today, we are launching a comprehensive 10-part masterclass specifically tailored for residents of the Pacific Northwest who are looking for a way out without burning their lives to the ground. In this first installment, we are solving the primary problem that paralyzes most people at the starting line: the fear of the unknown and the complexity of the initial filing. We are going to break down why Washington and Oregon handle your assets with completely different philosophies, how the 90-day cooling-off period can either be your greatest ally or your worst enemy, and the exact steps you need to take to ensure your paperwork is bulletproof before it ever hits a clerk's desk. By the end of this series, you will understand the potential outcomes of a navigated dissolution versus a blind one, and you will have the clarity needed to handle your case with the precision of a professional. To understand the 661 approach in the Pacific Northwest, we first have to look at the regional legal landscape. The Northwest is unique because it contains a stark divide in how property is viewed. Washington is one of the few community property states in the nation. This means that, historically, the court views almost everything acquired during the marriage as belonging equally to both parties. Oregon, conversely, operates under equitable distribution, which sounds similar but offers the court much more discretion to decide what is fair, which isn't always a 50-50 split. If you are living in Vancouver, Washington but working in Portland, Oregon, where you file is the single most important decision you will make. We have seen case studies where a spouse who filed in the wrong jurisdiction lost access to a significant portion of a retirement account simply because they didn't understand the statutory differences between the two sides of the Columbia River. The 661 methodology focuses on the preparation of the petition and the avoidance of the litigation trap. In the Pacific Northwest, many people believe that hiring a lawyer is the first step. However, historical trends show that the moment a process server knocks on a spouse's door with a surprise summons, the cost of the divorce triples instantly. The 661 philosophy advocates for a collaborative entry into the system. This begins with the petition for dissolution of marriage. In Washington, under RCW 26.09.030, the law requires a 90-day waiting period from the date the petition is filed and served before the court can finalize the divorce. This is often called the cooling-off period. Most people view this as a nuisance, but in a deep-dive strategy, this 90-day window is actually your most valuable asset. It is the time where all document preparation, asset discovery, and parenting plan negotiations should be completed. If you use this time correctly, you can walk into court on day 91 and have a judge sign your final decree in minutes. If you waste this time fighting over who gets the mid-century modern coffee table, you enter a cycle of motions and hearings that can last 18 months. Let's look at a case study involving a tech employee in the Seattle area. A common scenario in the Pacific Northwest. Let's call them Mark and Sarah. They had a home in Bellevue, 2 vehicles, and a significant amount of unvested stock options. Mark wanted to go the traditional route, hiring a high-price firm in downtown Seattle. Sarah opted for a more streamlined, document assistant approach similar to the 661 model. Mark's attorney immediately filed a motion for temporary orders, which cost $5,000 just to set a hearing date. Sarah, however, focused on the mandatory financial disclosure forms required by King County. By presenting a transparent, completed packet of information during the 90-day waiting period, Sarah was able to show Mark that the community property laws in Washington were going to split those stock options regardless of how many hours his attorney billed. They shifted from a litigated model to a mediated model, saving an estimated $40,000 in combined legal fees. This is the power of understanding the local rules, rather than just following the crowd into a courtroom. One of the most significant hurdles in the Northwest is the sheer volume of paperwork and the lack of standardization across counties. Filing in King County is vastly different from filing in Multnomah County or Pierce County. Each has its own local rules, its own color-coded forms, and its own expectations for how a parenting plan should be structured. The 661 method emphasizes the importance of the initial joinder. If both parties can sign the petition at the outset, you bypass the need for a formal service of process, which reduces the immediate emotional tension. In the Pacific Northwest culture, which often values privacy and conflict avoidance, this quiet filing approach tends to lead to much better long-term co-parenting outcomes. We also have to address the residency trap. To file for divorce in Washington, at least one spouse must be a resident or a member of the armed forces stationed in the state. There is no specific duration required, but you must be a resident on the day you file. Oregon, however, typically requires at least one spouse to have lived in the state for 6 months prior to filing. I have seen individuals move across the border to the Portland area and attempt to file immediately, only to have their case dismissed for lack of jurisdiction 3 months later, forcing them to start the entire process and the associated filing fees from scratch. This masterclass is designed to move you through these hurdles one by one. In this first part, your objective is to gather your data. You cannot utilize the 661 method if you do not have a clear picture of your date of separation. In the Pacific Northwest, the date of separation is a critical marker that stops the clock on the accumulation of community property. If you stay in the same house but sleep in separate rooms, is that a separation? The courts in this region look at the manifestation of intent. This means your actions must match your claim. If you are still filing joint tax returns or attending family functions as a couple, a judge might decide your community estate continued longer than you think, potentially giving your spouse a claim to a year's worth of your salary or bonuses that you thought were separate. As we progress through this series, we will dive into the specific forms, the summons, the petition, the confidential information form, and the vital statistics form. We will explain how to handle the notice of appearance, and why you should never ignore a document just because you haven't hired a lawyer yet. The goal here is to provide a roadmap that takes the mystery out of the Pacific Northwest legal system. We are moving from the what to the how, ensuring that your transition into the next chapter of your life is defined by logic and strategy, rather than emotion and debt. This is just the beginning of the deep dive into Divorce 661 in the Pacific Northwest. Stay focused, keep your documents organized, and prepare for the specific steps we will cover in the next part of this masterclass. Now that you have gathered your initial data and understood the regional landscape, we must move into the engine room of the 661 methodology, the asset and debt inventory. In the Pacific Northwest, specifically as we navigate the economic climate of 2026, the complexity of a household estate has evolved far beyond physical bank statements and paper deeds. We are living in an era where digital assets, fractional real estate interests, and complex employment compensation packages like restricted stock units or RSUs are the norm rather than the exception. If you miss a single entry on your initial disclosure, you are not just making a clerical error. You are potentially opening a door for your spouse's counsel to claim fraud or non-disclosure later in the proceedings, which can lead to a judge awarding a higher percentage of the community estate to the other party as a sanction. Imagine a scenario involving a couple in the Seattle tech corridor. Let's call them Alex and Jordan. They have been married for 8 years. Alex works for a major cloud computing firm and has been receiving stock grants since 2019. In 2026, many of these grants have vested, but many more are scheduled to vest over the next 3 years. Jordan believes that because those future shares haven't landed in the account yet, they aren't part of the divorce. This is a catastrophic misconception. In Washington, courts use a formula known as the time rule fraction, or the Berner formula, to determine what portion of those future vesting stocks belongs to the community. If you don't know how to calculate the numerator of months of marriage during the grant period versus the denominator of total months until vesting, you are essentially guessing with your financial future. Historical trends in King and Snohomish counties show that judges are increasingly precise with these calculations, and failing to disclose the grant schedule can stall your 661 filing for months of expensive discovery. The first step in this masterclass phase is the creation of a comprehensive disclosure packet. This is more than just a list of what you own. You need to categorize every item into 3 distinct columns: separate property, community property, and commingled property. This third column is where most divorces in the Northwest go off the rails. Imagine if Alex had $50,000 in a personal savings account before marrying Jordan. On their 3rd anniversary, they decided to use that money as a down payment for a home in Tacoma. The moment that separate money was mixed with a community mortgage and community income to pay the monthly notes, it became commingled. In a 661 approach, we don't just hope the judge sees it our way. We use a process called tracing. Tracing requires a literal paper trail showing the movement of every dollar from its separate origin into the community asset. Without these records, the court usually defaults to the presumption that everything is community property. In 2026, with the speed of digital banking, you must pull these records immediately because many financial institutions archive or delete detailed transaction histories after 5 to 7 years. Let's look at another case study, this time in Portland, Oregon. Meet Sam and Casey. They own a small craft brewery that has seen significant growth over the last 4 years. In Oregon's equitable distribution system, the court doesn't just split the brewery down the middle. They look at the contribution of each spouse. While Sam ran the daily operations, Casey managed the household and supported Sam's ability to work long hours. Historical trends in Multnomah County suggest that the non-working spouse is often entitled to a share of the business's increased value during the marriage. The 661 strategy here involves getting a neutral valuation expert early, instead of each spouse hiring their own appraiser, which leads to a battle of the experts and thousands in fees. The 661 model advocates for a joint expert. By agreeing on the valuation professional, you eliminate 50% of the conflict points before the first court appearance. Step 2 of this deep dive is the debt audit. In the Pacific Northwest, we are seeing a massive spike in hidden debt in 2026, often linked to high-interest fintech loans or buy now pay later services that don't always appear on a standard credit report. When you file your 661 petition, you are responsible for disclosing all liabilities. If Jordan has $20,000 in undisclosed credit card debt used for personal expenses, and Alex signs a decree that says they share all marital debts, Alex could be legally tethered to that debt even after the divorce is finalized. You must perform a deep dive credit sweep on both yourself and your spouse. Potential outcomes of ignoring this step include post-decree litigation that can cost more than the original debt itself. Now we must discuss the 2026 digital footprint. This is a critical component of the 661 method that traditional scripts often ignore. We are talking about cryptocurrency wallets, non-fungible tokens, and even high-value gaming accounts or digital storefronts. If one spouse has been quietly moving community funds into a decentralized finance platform, it leaves a trail on the blockchain. In the Northwest, forensic accountants are now using specialized software to map these transactions. If you are the spouse who is unaware of these assets, your 661 filing must include a request for digital discovery. If you are the spouse holding these assets, understand that the historical trend is moving toward total transparency. Attempting to hide digital wealth in 2026 is significantly harder than it was 5 years ago, and the legal repercussions for waste or fraud are severe. Step 3 involves the mandatory financial declaration. In Washington, this is known as the FL All Family 131. It is a grueling document that requires you to list your monthly expenses down to the last dollar for groceries, utilities, and even pet care. Most people rush through this, but the 661 Masterclass approach requires precision. Why? Because this document forms the basis for any potential spousal maintenance or child support. If you underestimate your expenses, you may receive less support than you need to survive in high-cost areas like Bellevue or Lake Oswego. If you overestimate, you lose credibility with the court. Case studies show that individuals who provide receipts and a 3-month average for their expenses are perceived as significantly more reliable, by judges than those who use round numbers like $500 for food. To add even more value here, we must talk about the 2026 housing crisis in the PNW. Many couples are currently trapped in a house with a 3% mortgage rate that they cannot afford to refinance at current market rates. The 661 method explores creative potential outcomes here, such as a deferred sale. This is where both parties stay on the deed for a set period, perhaps until a child graduates high school, to maintain the low interest rate and equity growth. However, this requires a rock-solid equity sharing agreement within your dissolution documents. Without specific language regarding who pays for a leaking roof in 2028 or what happens if one spouse wants to move a new partner into the home, a deferred sale can become a legal nightmare. As we move toward the conclusion of this part, you should have your spreadsheets open. You should have your tax returns for the last 3 years, your pay stubs for the last 6 months, and your retirement plan summary descriptions ready to go. The 661 process is built on the foundation of this data. If the foundation is weak, the entire structure of your divorce will crumble under the first sign of pressure from the opposing side. You are building a case that is so well documented and so transparent that it becomes difficult for anyone to argue with the logic of your proposed split. But there is a darker side to this process that we haven't touched on yet. What happens when the assets aren't the problem? What happens when the conflict isn't about the money, but about the time spent with your children? In the Pacific Northwest, the courts have a very specific way of viewing the best interests of the child, and it is not always what you would expect. If you think a 50-50 split is the default, you might be in for a shock depending on which county you are standing in. In the next part of this masterclass, we are going to dive into the high-stakes world of PNW parenting plans. We will look at why the first right of refusal clause is a double-edged sword, and the secret reason why the status quo is the most powerful phrase in a family law courtroom. Do not make a single move regarding your living situation until you hear what we have to say about the tactical errors of moving out too early. The moment you decide to end a marriage in the Pacific Northwest, your first instinct might be to pack a bag and head to a short-term rental in the Pearl District or a quiet Airbnb in the Cascades just to find some breathing room. In 2026, with the high-speed mobility of our society, this feels like a logical way to de-escalate tension. However, in the realm of 661-style strategic dissolution, moving out of the family home before a temporary parenting plan is in place is often the single most damaging tactical error a parent can make. When you walk out that door, you aren't just leaving a building. You are potentially walking away from the legal presumption of being a primary or equal caregiver. To understand why this is so dangerous, we have to look at the concept of the status quo. In family law courts across Washington, Oregon, and Idaho, stability is the gold standard. Judges are tasked with determining the best interests of the child, and in 2026, the historical trend shows that judges overwhelmingly prefer to keep a child's routine as consistent as possible during the trauma of a divorce. If you move out and leave the children in the family home with the other parent, you have inadvertently created a new status quo where the other parent is the primary residential provider, and you are the visiting parent. By the time you reach a temporary orders hearing, which could be 60 to 90 days after your initial filing, the other parent can argue that the children have adjusted to your absence and that a major shift back to a 50-50 split would be disruptive to their schoolwork and emotional health. Imagine a case study involving a couple in Tacoma. Let's call them Marcus and Elena. Marcus is a software project manager who often works from home. In early 2026, following a series of heated arguments, Marcus decides to move into a sleek apartment near the waterfront to give Elena some space. He assumes they will figure out a schedule later. For the next 3 months, Marcus sees the kids on Tuesday nights and every other weekend. When they finally stand before a Pierce County judge, Marcus asks for a week-on, week-off schedule. Elena's attorney argues that for the last 90 days, Elena has handled every morning routine, every doctor's appointment, and every soccer practice. The judge, looking at the recent historical data of what has actually been happening, decides that the kids are doing well under the current arrangement and denies Marcus's request for equal time. Marcus didn't lose his kids because he was a bad father. He lost his leverage because he prioritized temporary comfort over long-term legal positioning. The 661 methodology requires you to stay in the home if it is safe to do so, or to have a signed, notarized temporary parenting agreement in hand before you move a single box. If you must move, the step-by-step detail here is crucial. You must establish a written status quo agreement that explicitly states your move is temporary and that both parents agree to an immediate 50-50 residential schedule. Without this document, Your departure is a gift to the opposing side's litigation strategy. Now let's peel back the layers of the actual parenting plan. In the Pacific Northwest, we generally move away from the aggressive term custody and instead use residential time and decision-making authority. This is a vital distinction in the 2026 legal landscape. You can have joint decision-making authority, meaning you both must agree on major things like surgery, what school the child attends, or religious upbringing, even if one parent has the child 70% of the time. However, the true 661 masterclass secret lies in the granular details of the residential schedule. One of the most debated clauses in a PNW parenting plan is the first right of refusal. This clause states that if a parent is unable to care for the child during their scheduled time for a specific duration, usually 4 to 8 hours, they must contact the other parent and offer them the time before calling a babysitter or a grandparent. On the surface, this sounds like a beautiful child-centric idea. Why wouldn't you want the child to be with a parent? But in practice, especially in high-conflict cases, this becomes a tool for surveillance and control. Consider a scenario in 2026 Portland with a couple named Jamie and Alex. They have a 4-hour right of refusal clause. Jamie wants to take a Saturday afternoon yoga class and then grab coffee with a friend, totaling 5 hours. Under the clause, Jamie is legally obligated to call Alex. Alex, still feeling the sting of the divorce, uses this as an opportunity to interrogate Jamie about who they are meeting. If Jamie forgets to call and Alex finds out through social media or a mutual friend, Alex can file a motion for contempt of court. Historical trends in Multnomah County show that these clauses often generate more litigation than almost any other part of a parenting plan. The 661 advice? Be extremely cautious. If there is even a hint of high conflict, set the right of refusal to a high threshold, like 24 hours or overnight, or eliminate it entirely to preserve your autonomy. Another critical element is the primary caretaker standard. While many PNW judges aim for a 50-50 split, they still heavily weigh who has historically performed the daily parenting tasks. In 2026, we recommend keeping a parenting journal for at least 6 months prior to filing. This isn't a diary of your feelings. It is a data log. Who woke the children up? Who packed the lunches? Who communicated with the teachers? Who took them to the dentist? When you can present a spreadsheet showing that you performed 65% of these tasks over a half-year period, it becomes very difficult for the other parent to claim you were an uninvolved or secondary parent. Let's talk about the 2026 reality of parallel parenting. This is a strategy used when a 50-50 split is desired, but the parents cannot communicate without exploding. Unlike co-parenting, which requires a high degree of collaboration, parallel parenting involves a plan so detailed that the parents never actually have to speak. It specifies the exact lamp post at the park where the exchange happens. It dictates that all communication must occur through a monitored app like Our Family Wizard or Talking Parents, where nothing can be deleted and everything is admissible in court. It even predetermines which parent is responsible for which extracurricular activities. In the 661 model, a well-crafted parallel parenting plan is the shield that prevents a high-conflict spouse from dragging you back into court every 6 months. Finally, we must address the relocation trap. In Washington and Oregon, there are very strict laws regarding moving a child out of their current school district or state. If you are the primary parent and you decide in 2026 that you want to move from Seattle to Boise to be closer to family, you cannot just go. You must provide formal notice, and the other parent has a specific window to object. If they object, you are headed for a relocation trial, which is one of the most expensive and unpredictable types of litigation in the Northwest. Potential outcomes often include the parent being allowed to move, but the child being ordered to stay with the other parent. As we wrap up this deep dive into parenting mechanics, you should realize that your behavior today is the evidence for your trial tomorrow. Every text message, every missed pickup, and every temporary housing decision is being etched into a legal record that will define your relationship with your children for the next decade. But as heavy as the parenting plan feels, it is only half of the battle. Because where the children go, the money follows. In the Pacific Northwest, the calculation of child support is a rigid, math-driven process that can lead to some shocking financial realities in a high-inflation 2026 economy. If you think the child support worksheets are simple, you haven't seen how a shared residential credit can swing a payment by hundreds of dollars, or how extraordinary expenses for private school and club sports can drain your bank account before you even pay your own rent. In the next part of this masterclass, we are cracking open the financial vaults of child support and spousal maintenance. We will show you the income imputation trap and why being underemployed on purpose is a gamble that almost never pays off in front of a PNW judge. Do not sign a single financial declaration until you see how the 661 method handles the math of the future. Welcome to the financial reality of the 2026 Pacific Northwest. If you thought the emotional weight of a divorce was heavy, wait until you see the cold, hard math of the child support worksheets and spousal maintenance projections. In Washington and Oregon, we are seeing a significant shift in how courts view income in an era of remote work, side hustles, and high inflation cost of living adjustments. This part of the masterclass is dedicated to the number crunching that will define your lifestyle for years to come. We are going to move beyond the basic calculators you find online and look at the actual mechanics of income imputation, extraordinary expenses, and the spousal maintenance formulas that vary wildly depending on which side of the Columbia River you call home. Let us start with the foundation. The Child Support Worksheet. In Washington, the state uses the Washington State Child Support Schedule, or WSCSS. This is a rigid income shares model. The court looks at the combined monthly net income of both parents and finds a corresponding number on a predetermined table based on the age and number of children. Imagine a case study involving David and Chloe, a couple living in Kirkland, Washington, in 2026. David is a senior systems architect earning $200,000 a year, while Chloe has been working part-time in marketing, earning $45,000. In a traditional 661 filing, the first step is to calculate the basic support obligation. For two children under 12, the table might suggest a combined support need of $3,000. Because David earns roughly 80% of the household income, his share would be $2,400. However, the 2026 economic landscape adds a layer of complexity: the RSU and bonus trap. Historically, high earners tried to argue that their base salary was their only predictable income. In 2026, Pacific Northwest judges are increasingly savvy. They look at a 2-year historical trend of bonuses and stock vests to create an average monthly income. If David's RSUs added another $50,000 to his annual take-home, the court would include a fraction of that in his monthly income. The potential outcome here is a significantly higher transfer payment than David initially anticipated. The 661 strategy for this is transparency. By presenting a multi-year average early, David avoids the appearance of trying to hide income, which can lead to a judge applying an even more aggressive calculation as a penalty. Now let us discuss the income imputation gamble. This is where many people make a tactical error that backfires in court. Imagine if Chloe, wanting to maximize child support or spousal maintenance, decided to quit her marketing job and claim she had no income. In the Pacific Northwest, judges are not easily fooled by voluntary underemployment. Under Washington's RCW 26.19.071, if a parent is voluntarily unemployed or underemployed, the court shall impute income to that parent. This means the judge will act as if you are earning what you are capable of earning based on your work history, education, and the current 2026 job market. If Chloe has a degree and 10 years of experience, the court might impute her income at $75,000 even if she is currently making zero. Case studies show that parents who try this often end up in a financial hole because they are ordered to pay support based on money they aren't actually bringing home. Step 2 of the financial deep dive is the shared residential credit. This is the holy grail for many parents seeking a 50-50 parenting plan. In many Northwest jurisdictions, if the children spend an equal amount of time with both parents, the higher earning parent can request a deviation from the standard child support calculation. The logic is that the higher earner is already paying for a household, food, and utilities for the children half of the time. However, this is not automatic. In Washington, a deviation for shared residency is discretionary. A judge can deny it if they believe the lower earning household needs the full amount to maintain a basic standard of living for the children. In 2026, with rent in cities like Seattle and Portland reaching record highs, we are seeing more judges deny these credits to ensure the children have 2 viable homes. Next, we must tackle the hidden giant: extraordinary expenses. Child support covers the basics: food, shelter, and clothing. It does not cover the $6,000 a year elite soccer club, the private school tuition in Lake Oswego, or the orthodontic bills that are coming in 2027. The 661 method requires these to be addressed in the final decree using a proportional share. If David earns 80% of the income, He typically pays 80% of these extra costs. But what happens if Chloe signs the children up for an expensive coding camp without David's consent? Without a clause in your decree requiring mutual agreement for any expense over $500, you are inviting a decade of small claim-style bickering. One unique feature of the Pacific Northwest, specifically Washington, is post-secondary educational support. Unlike many other states, Washington allows a judge to order parents to pay for college. In 2026, with the cost of a 4-year degree skyrocketing, this is a massive future liability. Potential outcomes often include both parents being ordered to contribute based on their income at the time the child turns 18. The 661 strategy here is to set a cap, often tied to the cost of in-state tuition at the University of Washington, to prevent an open-ended financial obligation that could derail your retirement. Finally, we reach the most contentious topic, spousal maintenance, often called alimony. In the Northwest, there is no set formula for maintenance like there is for child support. It is based on one person's need and the other person's ability to pay. Historical trends suggest a rule of thumb of 1 year of maintenance for every 3 or 4 years of marriage, but this is highly subjective. Imagine if David and Chloe were married for 15 years. Chloe sacrificed her career growth to manage the household. In 2026, a court might order David to pay maintenance for 5 years to allow Chloe time to rehabilitate her career. The 661 method handles maintenance by focusing on the budget. This goes back to the mandatory financial declaration we discussed in Part 2. If Chloe can show a detailed, evidence-based budget that includes her 2026 rent, health insurance, and groceries, she has a much stronger case for a specific maintenance amount. Conversely, if David can show that after paying child support and his own high Seattle rent, he only has $2,000 left over, the court cannot order him to pay $3,000 in maintenance. You cannot squeeze blood from a stone, and the 661 strategy is to present the stone's reality before the judge makes an impossible order. As we conclude this deep dive into the financial mechanics, you should realize that your net monthly income is the only number that truly matters. Not your gross, not your potential, but what hits your bank account after the state takes its share. By understanding the imputation rules and the RSU calculations, you can negotiate from a position of data rather than emotion. But having the math right is only the beginning. What if your spouse is not being as honest as you are? What if that RSU schedule you saw last year has suddenly disappeared from their latest disclosure? In the world of high-stakes divorce, the truth is often hidden behind layers of encrypted files and shell companies. In the next part of this masterclass, we are going to explore the high-tech world of discovery. We will show you how to use a subpoena duces tecum to force the hand of financial institutions, and the one digital trail that almost every person forgets to hide. Prepare yourself, because we are about to go on a hunt for the assets they think you will never find. The hunt for the truth in a Pacific Northwest divorce often begins not in a courtroom, but in the quiet digital trails left behind by a spouse who believes they are being clever. In the 2026 legal landscape, the process of discovery has evolved from boxes of paper to petabytes of data. If you are following the 661 methodology, you understand that information is your only real currency. When the voluntary disclosures we discussed in the previous part prove to be incomplete or suspicious, we move into the formal phase of discovery. This is the stage where the power of the state is put behind your search for transparency. In Washington and Oregon, discovery is governed by strict civil rules that allow you to compel the production of documents, answers to written questions, and even sworn testimony before a trial ever begins. Imagine a scenario in 2026 involving a couple in Bend, Oregon. Let us call them Taylor and Jordan. Taylor is a freelance consultant who has seen a suspicious dip in reported income over the last 18 months, conveniently coinciding with the marital breakdown. Jordan, working a stable job in healthcare, suspects that Taylor is funneling cash into a separate account or perhaps deferring client payments until after the final decree is signed. Under the 661 protocol, Jordan does not just argue about this in mediation. Jordan initiates formal discovery, starting with interrogatories and requests for production. Interrogatories are a set of written questions that the other party is legally required to answer under penalty of perjury. In the Pacific Northwest, there is typically a limit, often around 30 to 40 questions, so every question must be a precision strike. Instead of asking, "Do you have other bank accounts?" a 661 trained approach asks, "List every financial institution, including digital wallets, neobanks, and offshore entities, where you have held any interest either individually or jointly at any time in the last 36 months. Following this are the requests for production, which are the demands for the actual documents. This is where you demand the native files of tax returns, the full transaction history of Venmo and PayPal accounts, and even the metadata-heavy logs from business accounting software like QuickBooks. Historical trends show that when a spouse is faced with a formal, numbered request for production, the missing information often miraculously appears. But what happens when the spouse continues to stonewall? This is where the subpoena duces tecum becomes your most powerful tool. A subpoena duces tecum is a court-ordered command for a third party, someone other than your spouse, to produce documents or evidence. In 2026, this is the primary way we bypass a dishonest spouse. If Taylor claims they do not have the bank records Jordan is looking for, Jordan's legal team issues a subpoena directly to the registered agent of the bank. Because the bank has no emotional stake in the divorce, they will simply pull the records from their servers and mail them to the requesting party. We have seen case studies where a subpoena to a local credit union in Spokane revealed a secret savings account with $40,000 that the husband had conveniently forgotten to mention on his financial declaration. You can also subpoena employers. If you suspect your spouse is sandbagging, purposefully delaying a bonus or a promotion to keep their income looking low, a subpoena to their Human Resources Department for their personnel file, bonus structure, and unvested RSU schedule will reveal the truth. In the high-tech corridor of the Northwest, where compensation is often tied to performance metrics and future grants, these employer subpoenas are essential. They provide a roadmap of what the spouse's income will likely be in 2027 and 2028, which is critical for setting long-term spousal maintenance. Now, let us talk about the one digital trail that almost every person forgets to hide in 2026, the shared cloud environment. Many couples in the Pacific Northwest have shared Amazon Prime accounts, shared iCloud storage, or shared Google Workspaces. Imagine if Jordan, while looking for a digital copy of a shared tax return, finds a folder in the family's shared Dropbox titled Consulting 2026. Inside, there are invoices for work Taylor claimed was never performed. Because this was a shared account that both parties had the password to for years, the expectation of privacy is often lower. However, a word of caution in this masterclass. You must be extremely careful not to violate federal or state privacy laws like the Electronic Communications Privacy Act. The 661 method emphasizes using discovery to get these documents legally rather than hacking into an account, which could lead to your evidence being thrown out or even criminal charges. The next level of discovery involves the deposition. A deposition is an out-of-court session where your attorney asks your spouse questions under oath in front of a court reporter. In 2026, many of these are conducted via high-definition video conferencing. This is where the 661 methodology shifts from data gathering to psychological pressure. When a spouse has to sit for 4 hours and answer detailed questions about why their lifestyle costs $10,000 a month while they claim to only earn $4,000, the cracks in their story begin to widen. Potential outcomes of a well-run deposition include a sudden willingness to settle. Once a spouse realizes that their financial inconsistencies are now part of a sworn transcript that a judge will read, the litigation posturing usually ends. For high-asset cases, especially those involving the booming 2026 real estate market in the Northwest or complex business valuations, you may need a forensic accountant. This professional is like a private investigator with a CPA license. They perform what is known as a lifestyle analysis. They look at your total household spending and compare it to the reported income. If the math does not add up, if you are spending $100,000 a year but only reporting $60,000 in income, the forensic accountant calculates the unexplained wealth. In Washington, a community property state, the court can charge that hidden wealth against the hiding spouse's share of the remaining assets. If Taylor hid $50,000, the judge might give Jordan an extra $50,000 from the sale of the family home to balance the scales. The step-by-step detail here is to always follow the money's exit points. Check the cashback at grocery stores on debit card statements. Look for recurring transfers to unknown accounts. Check the authorized users on credit cards. We have seen cases where a spouse was funding a secret apartment by adding the landlord as an authorized user on a business card. The digital trail is always there. It just requires the discipline of the 661 method to find it. As we conclude this part of the deep dive, understand that discovery is the great equalizer. It takes the power away from the spouse who controls the checkbook and gives it back to the spouse who has the truth on their side. But finding the money is only half the battle. Once you have the data, once you have the subpoenas, and once you have the deposition transcripts, you have to do something with them. You are now at a crossroads. You can take this evidence and head straight for a scorched earth trial that will cost you another $50,000, or you can use it as leverage in the most critical phase of the 661 process. Most people think that a judge is the one who decides their fate, but in the Pacific Northwest, 95% of cases are settled before they ever reach a courtroom. The secret to a successful exit is not winning at trial, but winning at the negotiation table. In the next part of this masterclass, we are going into the room where it happens, mediation. We will show you why the mediator's proposal is a trap you need to watch out for, and the 3 words you must never say if you want to walk away with your fair share. The game is about to change, and the stakes have never been higher. You have the data, you have the digital trails, and you have the sworn testimony. Now, you enter the room where the vast majority of Pacific Northwest divorces are actually decided. In 2026, the court systems in Washington and Oregon are under more strain than ever before, with trial dates often pushed 18 to 24 months into the future. Because of this backlog, mediation is no longer just a suggestion. In counties like King, Snohomish, and Multnomah, it is a mandatory gatekeeper. If you cannot prove to a judge that you have made a good faith effort to settle your case through a certified mediator, you will likely find your trial date vacated. This is the 661 pivot point, where the cold math of discovery meets the high-stakes psychology of negotiation. Imagine a scenario in 2026 involving Olivia and Ethan. They live in a high-growth area near Redmond, Washington. Ethan is a senior director at a global tech firm, and Olivia has spent the last decade managing their household and a small boutique consulting firm. They are fighting over a community estate valued at $4 million, including a home with a massive amount of trapped equity and a complex web of unvested stock. They have spent the last 6 months in a discovery war. Now they are sitting in separate virtual breakout rooms on a 10-hour Zoom mediation call. The mediator, a retired superior court judge, is toggling between them. This is what we call shuttle diplomacy. The mediator's job is not to decide who is right or who is the better parent. Their sole objective is to get a signature on a piece of paper so they can clear another case off the regional docket. In the 661 methodology, you must understand that the mediator is a neutral party, but neutrality does not always mean they are looking out for your best interests. They are looking for the path of least resistance. Historical trends show that mediators often apply the most pressure to the party they perceive as the most reasonable. If you are the person who is being logical, the mediator might ask you to give up another 5% of the house equity just to close the gap because they know the other spouse is too volatile to budge. This is the first trap of the mediation process, the tax on the reasonable. To avoid this, the 661 strategy employs the anchor effect. Step by step, you do not wait for the mediator to suggest a starting point. Your attorney or your 661 prepared memorandum must set the anchor. If you want a 50-50 split, your opening proposal should be 60-40 in your favor, backed by the specific data points you gathered in the discovery phase. When you set the anchor first, the entire negotiation revolves around your numbers rather than your spouse's. We have seen case studies where the party who submits their settlement memorandum 48 hours early, complete with color-coded spreadsheets of the 2026 tax implications of their proposed split, ends up controlling the narrative of the entire day. Now we must address the 3 words you must never say in a Pacific Northwest mediation if you want to walk away with your fair share. Those words are "I don't care." In a 10-hour session, usually around hour 7 when the caffeine has worn off and the emotional exhaustion is peaking, people start to say things like, "I don't care about the furniture," or "I don't care about the 2025 tax refund, I just want this over." The moment those words leave your mouth, the mediator knows you have reached your breaking point. They will immediately go to the other room and tell your spouse's counsel that you are ready to fold. In the 2026 economic climate, those small items you claim not to care about, the household goods, the credit card points, the small checking accounts, often add up to $20,000 or $30,000. In a 661 approach, you care about every single line item until the final signature is dry. This leads us to the most dangerous moment of the day, the mediator's proposal. Imagine it is 5:30 p.m. Everyone wants to go home. The parties are still $50,000 apart on a cash equalization payment. The mediator enters your room and says, "Look, I've talked to both sides. If I can get Ethan to agree to pay you $40,000 instead of $50,000, but you let him keep the Tesla, would you sign that right now?" This is a take it or leave it offer. It is a potential outcome that feels like a relief in the moment, but is often a tactical error. Historical trends suggest that people who sign a mediator's proposal under extreme fatigue often experience significant buyer's remorse within 48 hours. However, in Washington, once you sign what is known as a CR2A agreement, it is a binding contract. Under Civil Rule 2A, it is nearly impossible to back out of a signed settlement unless you can prove outright fraud or extreme duress, and being tired does not count as legal duress. In Oregon, the process is similar but governed by different statutes. The mediation communications are confidential, but once a memorandum of shared understanding is signed, it becomes the blueprint for your final judgment. If you are in Portland in 2026, you must ensure your mediation agreement includes specific language regarding the 2026 real estate market. If you agree to sell the family home, who chooses the agent? What is the minimum listing price? If the house doesn't sell in 30 days, how much is the price reduced? Without these step-by-step details in the mediation agreement, you are simply trading a divorce lawsuit for a post-divorce breach of contract lawsuit. Another high-depth detail of the 661 Masterclass is the 2026 tax impact analysis. In 2026, with the sunsetting of certain federal tax provisions, the way we divide retirement accounts like 401ks and IRAs is different than it was a decade ago. $1 in a Roth IRA is worth significantly more than $1 in a traditional 401k because of the future tax liability. If you are in mediation and the mediator suggests a simple 50-50 split of all accounts, they are ignoring the fact that one person is inheriting a massive future tax bill. The 661 strategy requires a tax-affected calculation. You should only agree to a split that accounts for the net value after taxes. We have seen case studies where a spouse thought they were getting $1 million in assets, only to realize that after the mandatory 2026 tax hits, they actually only received $750,000. The emotional management of the day is also a tactical component. In the Pacific Northwest, we see a high volume of what we call high-conflict personalities in mediation. If your spouse is using the session to vent their grievances or relitigate the reasons for the breakup, the 661 method is to ignore the bait. Every time you respond to an emotional jab, you are paying the mediator and your attorney $500 an hour to listen to it. The most successful mediations are those where one party remains a ghost, totally unresponsive to the drama and hyper-focused on the spreadsheet. This is how you win a war of attrition. You make it clear that you are willing to stay until 3 a.m. if necessary to get the math right. As the sun sets on your mediation day, you will either have a signed settlement or a failed session. If you have followed the 661 steps, a failed session isn't necessarily a defeat. It is simply a confirmation that the other side is being unreasonable, which gives you a clear path to trial. But for most of you, this will be the day your marriage legally ends in spirit. You will sign the document, the Zoom call will end, and you will be left with a piece of paper that dictates your financial and parental future. But even with a signed agreement, the work is not finished. A mediation agreement is not a final decree of dissolution. There is a specific high-risk window between the signature and the judge's final stamp where things can go horribly wrong. What happens if your spouse refuses to move out? What if they start draining the accounts before the QDRO is processed? In the next part of this masterclass, we are moving into the endgame, finalizing the decree and asset transfer. We are going to show you the secret of the Qualified Domestic Relations Order, and the one document you must file with the county recorder to ensure your spouse doesn't take out a secret line of credit against your name. The finish line is in sight, but the final steps are the most treacherous. That specific document is the lease pendens, or a notice of pendency of action. In the legal landscape of the Pacific Northwest in 2026, where real estate values remain the primary driver of household wealth, a lease pendens acts as a formal red flag to the world. It is filed with the county auditor or recorder, whether in King County, Multnomah, or Ada, and it effectively clouds the title of the property while the dissolution is pending. This prevents a disgruntled spouse from attempting to sell the home, or more commonly, taking out a predatory secondary loan against the equity to fund a legal battle or a new life before the judge has divided the assets. Without this filing, your spouse could technically walk into a bank, leverage their status as a co-owner, and drain $200,000 of community equity in 48 hours. By the time you find out, the money is in an unextraditable digital wallet, and your share of the house has vanished. The treacherous gap between signing your settlement and the judge's final signature is where most 661 strategies are either solidified or destroyed. Imagine a case study involving Robert and Amanda, a couple in Spokane, Washington. They reached a full agreement in mediation in June of 2026. They signed a CR2A agreement, which is the binding settlement contract in Washington state. Robert was to keep the house and pay Amanda a cash equalization of $150,000. However, the attorney for Robert took 3 weeks to draft the final decree of dissolution. During those 21 days, the market shifted, and Robert's employer announced a massive layoff. Suddenly, the bank that had tentatively approved Robert's refinance pulled the offer. Because the final decree had not been entered by the court, Amanda was still legally on the hook for the mortgage, and Robert had no way to pay her the cash. They were stuck in a legal purgatory. The 661 methodology teaches that you must have a backup plan, a fail-safe clause, written into your agreement that dictates exactly what happens if a refinance fails, usually a mandatory sale of the property within 30 days. Once the judge finally signs the general judgment of dissolution in Oregon or the final decree of dissolution in Washington, your work has actually just begun. The paper in your hand is merely a permission slip to start the real work of asset transfer. Step 1 of this high-depth finalization is the quitclaim deed and the accompanying real estate excise tax affidavit. In Washington, transferring property between spouses during a divorce is generally exempt from the excise tax under W 458-61A-203, but you must file the affidavit correctly with the county treasurer. If you fail to do this or if you wait too long, you could be hit with a tax bill for thousands of dollars. The 661 protocol requires that the quitclaim deed be signed at the same time as the final decree. You do not leave the courthouse or the final signing meeting without that deed in your possession. You then drive it directly to the county recorder's office. If you rely on your spouse to do it, you are gambling with your credit. Let us look at the potential outcomes of the refinance trap. In the 2026 economic environment, interest rates have remained a significant barrier to household mobility. If you are the spouse leaving the home, you want your name off that mortgage immediately. Being on a mortgage for a house you no longer live in prevents you from qualifying for a new loan for your own residence. Historical trends show that many spouses try to be nice and give their ex-husband or ex-wife a year to refinance. This is a mistake. The 661 method advocates for a 90-day hard deadline. If the refinance is not completed in 90 days, the house must be listed for sale immediately. To add depth to this, your decree must include a hold harmless and indemnification clause. This means that if your spouse fails to pay the mortgage during that 90-day window, and it hits your credit, you have the legal right to sue them for the damages to your financial standing. It is a sword you hope never to use, but you must have it in your scabbard. Next, we must enter the highly technical world of the Qualified Domestic Relations Order, or QDRO. This is a separate legal order required to split a private retirement account like a 401k or a pension. Most people assume the final decree handles this. It does not. A 401k administrator will look at your divorce decree and tell you it is worthless to them. They require a QDRO that matches their specific company plan. In 2026, the backlog for QDRO processing is significant. Case studies show that individuals who wait until after the divorce is final to start the QDRO process often wait 6 to 9 months to receive their funds. During that time, if the market drops, your share of the account might lose significant value. The 661 strategy involves hiring a QDRO specialist during the discovery phase to have the order pre-approved by the plan administrator before the judge ever signs the final decree. This ensures that the moment the divorce is official, the QDRO is filed, and your retirement assets are moved into your own name, protecting you from market volatility and your ex-spouse's future creditors. Step 3 of the finalization process involves the Department of Licensing. In the Pacific Northwest, your vehicles are often community property. Even if the decree says the 2024 electric SUV is yours, the title at the DOL still says both names. You must take a certified copy of your decree and a bill of sale to the licensing office to update the title. While you are there, you must also address the insurance. Potential outcomes of failing to separate car insurance policies include being liable for an accident your ex-spouse has 3 months after the divorce. In 2026, insurance companies are increasingly aggressive about looking for ways to deny coverage. If they see 2 people on a policy who no longer live at the same address, they may use that as grounds to cancel the policy entirely. Now, let us discuss the final audit of your digital and financial identity. This is a step-by-step checklist that is often ignored, but is vital for your long-term security. You must go through every single account you own and update your beneficiary designations. Your divorce decree might revoke your ex-spouse's right to your life insurance by law, but if you die and they are still the named beneficiary on the policy, the insurance company will likely pay them anyway. forcing your family into a costly legal battle to recover the funds. You must also update your emergency contact information at your workplace, your doctor's office, and your children's school. Imagine if your child has an emergency in late 2026, and the first person the school calls is the spouse you just spent 2 years fighting in court. To add even more value to this masterclass, we have to talk about the 2026 security freeze. The moment your divorce is final, you should place a freeze on your credit reports with Equifax, Experian, and TransUnion. This prevents your ex-spouse from using your social security number, which they obviously know, to open new accounts in your name. Historical trends in the Northwest show a spike in identity revenge, where a bitter spouse opens multiple lines of credit just to destroy the other person's financial future. A credit freeze is your primary defense. As we reach the conclusion of this part, you should feel a sense of cautious relief. You have the papers, you have the deeds, and you have the QDROs in motion. You have protected your credit and secured your assets. But there is one final piece of the 661 methodology that people rarely talk about until it is too late. The law in the Pacific Northwest is not static. A parenting plan that works for a 5-year-old in 2026 will be a disaster for a 10-year-old in 2031. A child support order based on a 2026 salary will be obsolete the moment one of you gets a promotion or the economy shifts again. If you think your interaction with the court system ends when the judge hits the gavel, you are mistaken. The final chapter of this masterclass is about the future. It is about how to live under these orders without ending up back in court every 6 months for a contempt hearing. In the next part, we are going to dive into post-decree enforcement and modifications. We will show you the 2-year rule for changing child support and the exact evidence you need to collect today to win a modification trial 3 years from now. The divorce is over, but the management of your new life has just begun. Stay tuned because the final steps are what turn a successful divorce into a successful future. The ink on your final decree might be dry, but in the Pacific Northwest, the legal journey often enters a second, more technical phase known as the post-decree management period. In the year 2026, we are seeing a record number of cases returning to the courtroom within 24 months of the initial judgment. This happens because life in the Northwest, with its volatile tech economy and shifting housing market, does not stand still. If you are operating under the 661 methodology, you must understand that your decree is a living document. It is the rulebook for your new life, and just like any rulebook, it requires enforcement and occasionally updates to reflect new realities. The first major hurdle many face is the issue of non-compliance. Imagine a scenario involving a father named Michael living in Renton, Washington. It is late 2026, and his ex-spouse has consistently failed to drop the children off at the designated exchange point in Bellevue on time, often arriving 2 hours late or skipping weekends entirely. Michael's first instinct might be to call the local police, but in the Pacific Northwest, law enforcement rarely intervenes in civil parenting disputes unless there is an immediate safety threat. Instead, Michael must utilize the motion for contempt of court. In a 661-style enforcement action, you do not just file a grievance, you build a forensic record. Historical trends show that judges in King and Pierce counties are exhausted by he said, she said arguments. To win a contempt motion, Michael needs a log. He should have a spreadsheet or a specialized parenting app record showing every late arrival, every missed phone call, and every text message where the other parent refused to follow the decree. Step by step, the process involves filing a motion for order to show cause. This is a document that asks the judge to command the other parent to appear in court and explain why they shouldn't be held in contempt for violating a clear court order. Potential outcomes for a first-time contempt finding often include a stern warning and an order for make-up parenting time. But repeat offenders can face fines or even an order to pay the other party's legal fees. This is the sort of enforcement, and it is designed to ensure that the 661 plan you work so hard to build is actually followed. But what happens when the rules of the game need to change because the players have changed? This brings us to the crucial 2-year rule for child support. In Washington state, specifically under RCW 26.09.170, you have the right to request an adjustment of child support every 24 months without having to prove a substantial change in circumstances. This is a streamlined process designed to keep support levels in line with current economic realities. Imagine if Michael's ex-spouse, who was earning $60,000 when they divorced in early 2024, has now, by late 2026, secured a promotion to a senior role earning $120,000. Under the 661 method, Michael does not need to prove she did this to spite him. He simply points to the calendar and the new pay stubs. In a high-inflation 2026 economy, these periodic adjustments are essential to ensure that the financial burden of raising children remains equitably shared. Beyond the simple 2-year adjustment lies the more complex territory of a modification, based on a substantial change in circumstances. This is the threshold you must cross if you want to change the actual parenting schedule, or if you want to modify support before the 2-year mark. In the Pacific Northwest, a substantial change must be something that was not contemplated at the time the original decree was signed. A career move from Portland to a remote position in the Olympic Peninsula, a significant health shift, or a child's changing educational needs can all qualify. Let us look at a case study involving a mother named Sarah in Eugene, Oregon. In 2026, Sarah's teenage son begins struggling with a severe learning disability that requires a specialized private school curriculum only available in a different district. Her original 2024 parenting plan did not account for this. To modify the plan, Sarah must first pass the adequate cause hearing. In Washington and Oregon, this is a gatekeeper phase where a judge reviews the written evidence to decide if there is even enough merit to hold a full trial. Many people fail at this stage because they provide emotional pleas instead of data. Sarah's 661 strategy involves providing the educational testing results, the school's recommendation, and a detailed plan of how the new schedule will benefit the child's specific needs. Historical trends suggest that when a modification is framed around the child's objective requirements, rather than the parent's convenience, it is significantly more likely to be granted. Then there is the issue of spousal maintenance modifications. Unlike child support, which is almost always modifiable, spousal maintenance depends heavily on the specific language in your 2026 decree. In the Pacific Northwest, some decrees are written as non-modifiable, meaning that even if the paying spouse loses their job or the receiving spouse wins the lottery, the payments remain the same. However, most standard orders allow for modification if there is a substantial change in economic circumstances. If the person paying maintenance suffers a legitimate, involuntary job loss in the shifting 2026 labor market, they must file a petition to modify immediately. You cannot simply stop paying. If you stop paying without a court order, the debt continues to accrue with interest, often at 12% per year in the Northwest, and it cannot be discharged in bankruptcy. The 661 protocol is to file the motion the same week the layoff notice is received, as the court generally can only retroactively modify support back to the date the paperwork was served on the other party. We also have to discuss the evidence vault. In 2026, your digital trail is your best friend or your worst enemy in a modification case. If you are claiming you need more support, but your social security records show you have been taking luxury vacations in Whistler, your case is over before it begins. Conversely, if you are seeking more time with your children, your GPS logs, your communication records through apps like Our Family Wizard, and your school volunteer hours are the data points that will win your case. The 661 method teaches you to act every day, as if a judge is watching your digital footprint. As we deepen this masterclass, understand that the goal of post-decree management is not to stay in a state of perpetual war. It is to maintain the integrity of the agreement. When both parties know that the other is tracking the data and is willing to use the sword of enforcement, or the shield of modification, they are ironically more likely to cooperate. The 661 approach uses the threat of legal precision to foster a culture of compliance. However, there is a specialized area of post-divorce life that catches almost everyone off guard in the Pacific Northwest, especially as we navigate the complex tax codes of 2026. What happens when the IRS comes knocking because of a joint return you filed while you were still married? Or what happens when you realize your ex-spouse hasn't paid their share of the extraordinary expenses for the last 12 months and now owes you $10,000? The final chapters of this masterclass are where we separate the amateurs from the professionals. We are about to enter the world of the 661 final audit, a deep dive into the tax traps of 2026 and the secret world of Qualified Domestic Relations Order, QDRO, disasters that can bankrupt your retirement years after the divorce is settled. In the next part, we are going to expose the 5 tax mistakes that people in Washington and Oregon make every single year, and the one IRS form that can save you from your ex-spouse's financial negligence. You have come this far. Do not let a tax lien or a botched pension split ruin the new life you have built. The most technical part of the deep dive starts now. The IRS form that can save your financial future is Form 8857, the Request for Innocent Spouse Relief. In the Pacific Northwest, where high-earning tech couples often have complex joint filings involving stock options, capital gains, and multi-state income, this document is a critical safety net. Imagine a scenario in late 2026 involving a couple in Bellevue. Let us call them Jason and Maria. Jason was a high-level executive who handled all the household finances, including the tax filings. After their divorce was finalized in 2025, Maria received a notice from the IRS claiming that their joint 2024 return underreported capital gains from a secret cryptocurrency account Jason had managed. The IRS is now demanding $80,000 in back taxes, interest, and penalties. Because they filed jointly, Maria is legally on the hook for the entire amount, even if she never knew the account existed. Under the 661 methodology, Maria does not simply accept this debt. She utilizes Form 8857. To qualify for innocent spouse relief in 2026, Maria must prove three things. First, that there is an understated tax on the joint return due to erroneous items of the other spouse. Second, she must show that at the time she signed the return, she did not know, and had no reason to know, that there was an understatement. Third, taking into account all the facts and circumstances, it must be inequitable to hold her liable for the understatement. Historical trends show that the IRS looks closely at the educational level and business experience of the spouse seeking relief. In Maria's case, because Jason had exclusive control over the financial software and bank passwords, she has a strong argument for separation of liability. This allows the IRS to allocate the tax deficiency between the two ex-spouses, meaning Maria would only be responsible for the portion of the tax related to her own income. Without this 661 technical maneuver, Maria could see her wages garnished or a lien placed on the home she fought so hard to keep in the divorce. This leads us into the 2026 tax landscape of the Pacific Northwest, which has undergone a massive shift due to the sunsetting of the Tax Cuts and Jobs Act. In 2026, many of the tax protections and standard deduction levels that residents of Washington and Oregon relied on for the last decade have reverted to older, more complex rules. In Washington, we are seeing the continued impact of the state's capital gains tax on high-value assets. If your divorce decree requires you to sell a large block of stock to pay an equalization grant to your spouse, you must account for the 7% tax on gains over the exemption threshold. We have seen case studies where a spouse agreed to a cash payout based on the gross value of the stock, only to realize after the sale that they were responsible for a six-figure tax bill that the decree failed to mention. The 661 strategy requires a tax-affected valuation of every asset before the final signature is ever placed on a settlement. In Oregon, the situation is even more nuanced because of the state income tax. In 2026, Oregon residents must be wary of the kicker credit and how it is allocated between ex-spouses. If you were married during the year the tax surplus was generated but are divorced when the credit is issued, who gets the money? The 661 method dictates that your final judgment must explicitly state how future tax refunds and credits will be split. If you leave this to chance, the Oregon Department of Revenue will typically send the refund to the first person listed on the last joint return, which can lead to yet another round of expensive litigation to recover your half. Now let us move to the most technical disaster zone in family law, the botched pension split. While we touched on QDROs in a previous part, the 2026 reality of defined benefit plans, like those held by Boeing employees in Everett or state employees in Salem, requires a deeper understanding of the coverture fraction. Imagine if Maria is entitled to half of Jason's pension. Most people think this means she gets 50% of whatever he receives, but the law uses a specific math formula. The number of months the couple was married while Jason was in the plan, divided by the total number of months Jason was in the plan at the time of retirement, multiplied by 50%. The 661 technical trap here is the survivor benefit. If the QDRO is drafted as a shared interest order and Jason dies before he starts drawing his pension, Maria might receive absolutely nothing. The pension simply vanishes back into the plan. To protect yourself, the 661 methodology insists on a separate interest order. This carves out a piece of the pension and puts it in Maria's name, as if she were a participant in the plan herself. This way, her benefit is not tied to Jason's life expectancy or his future retirement choices. Furthermore, you must ensure the order includes a former spouse survivor annuity clause. Historical trends in the Northwest show that this is the most common mistake made by general practice attorneys. If Jason remarries and dies without this clause being explicitly stated in the QDRO, his new spouse will receive the survivor benefits, leaving Maria with zero, regardless of what the divorce decree said. Beyond the retirement accounts, we have the extraordinary expenses reimbursement trap. In the Pacific Northwest, many parents have proportional share agreements for things like uninsured medical costs, tutoring, and extracurricular activities. In 2026, with the cost of braces reaching $8,000 and competitive sports fees climbing into the thousands, these reimbursements are significant. The 661 protocol requires a strict 30-day rule. You must provide the receipt to the other parent within 30 days of the expense, and they must pay within 30 days of receipt. If you let these expenses pile up for 2 years and then try to collect $10,000 at once, a judge may rule that you waived your right to reimbursement through laches, a legal principle that says you waited too long to assert your rights. Let's look at a case study involving a hidden tax lien. Jason, feeling the financial pressure of the 2026 economy, decides to defer paying the property taxes on an investment property in Bend, Oregon, that was awarded to Maria. Because the tax bill is mailed to the property address and Maria hasn't updated the billing information yet, she is unaware that the county is preparing for a tax foreclosure. The 661 final audit requires a title search and a tax clearance certificate for every piece of real estate involved in the split. You do not accept a deed until you have proof that the taxes are current. As we conclude this technical deep dive, you should realize that a divorce in the Pacific Northwest is not a single event. It is a series of interconnected financial transactions that continue long after the court hearing. You are managing a transition that involves the IRS, state tax authorities, plan administrators, and county recorders. The 661 method is the framework that ensures none of these entities can pull the rug out from under your new life. You have the forms, you have the math, and you have the strategic foresight to avoid the traps that bankrupted previous generations of divorcees. But even with the technicalities mastered, there is one final wall to climb. All the spreadsheets and tax forms in the world cannot prepare you for the psychological shift of the new normal. How do you handle the first holiday after the 661 process is complete? How do you manage the shadow conflict that often persists even after the legal battle is won? And most importantly, what is the one thing you must do in the first 30 days of 2027 to ensure that your 2026 divorce stays in the past? In the final part of this masterclass, we are going beyond the law and the money to discuss the exit strategy for the soul. We will show you the clean break protocol and the final secret to turning your 661 experience into the greatest comeback of your life. The finish line is 10 minutes away. Let's get there together. The clean break protocol begins the moment the final gavel falls. But in the digitally saturated landscape of the 2026 Pacific Northwest, the physical separation is often the easiest part. The true challenge lies in the invisible tethers that remain. Step 1 of the 661 Clean Break Protocol is a comprehensive digital audit that goes far beyond simply changing a Netflix password. In the high-tech corridors of Seattle, Bellevue, and Portland, many households are managed by integrated smart systems. Imagine a case study involving Emily, a project manager in South Lake Union. 2 weeks after her divorce was finalized in early 2026, she realized her ex-spouse still had administrative access to their home security cameras and the smart thermostat. Every time she came home or adjusted the temperature, a notification was sent to his device. Historical trends show that these micro-interactions are not just annoying. They are a primary source of post-divorce surveillance and anxiety. The 661 method requires a scorched earth approach to digital identity. You must revoke all shared tokens, reset the factory settings on home automation hubs, and most importantly, perform a clean install on your primary mobile devices to ensure no location sharing apps remain active in the background. This leads us directly into the management of the new normal, specifically the first holiday season of 2026. In the Pacific Northwest, where the winter months are defined by gray skies and short days, the emotional weight of a modified family structure can feel compounded. Imagine a rainy Thanksgiving in Tacoma. According to your new parenting plan, you have the children for the first half of the day, with an exchange scheduled for 3 p.m. The potential outcome of a traditional face-to-face exchange during a high-stakes holiday is often a resurgence of the very conflict you just spent thousands of dollars to resolve. The 661 strategy for this is the drop-and-go maneuver. Instead of a driveway exchange that invites lingering stares or last-minute arguments over a forgotten coat, you utilize a neutral, public location. In 2026, many parents are using well-lit, camera-monitored community exchange zones located near local libraries or transit centers. You treat this exchange with the professional distance of a high-level courier. You arrive on time, you ensure the transition is smooth for the children, and you depart immediately. By removing the opportunity for dialogue, you remove the opportunity for drama. As you navigate the end of 2026, you will likely encounter what we call shadow conflict. This is the subtle, often passive-aggressive resistance to the new order. It manifests as a late child support payment by exactly 24 hours, a refusal to use the agreed-upon parenting app, or a series of urgent, non-emergency texts during your designated personal time. The 661 approach to shadow conflict is the communication fortress. You must stop treating your phone as an open door. Step by step, you disable all notifications from your ex-spouse across all platforms except for one dedicated, court-approved communication portal. You establish a specific window, perhaps every Tuesday and Friday morning, where you log in, address all logistical matters with the brevity of a corporate memo, and then close the vault. Historical trends suggest that when you stop rewarding shadow conflict with an immediate emotional reaction, the other party eventually loses interest in the game. You are training them to interact with you as a business partner in the corporation of your children's lives, rather than as a former romantic foil. Now we must focus on the one thing you must do in the first 30 days of 2027 to ensure your 2026 divorce stays in the past. The total estate reset. While your divorce decree legally ended your marriage, it did not automatically update your broader legal existence. Imagine a scenario where a resident of Lake Oswego, let us call him Mark, finalized his divorce in November 2026. In January 2027, Mark suffers a minor medical emergency that requires a short hospital stay. Because he failed to update his healthcare power of attorney and his living will, the hospital's legal department identifies his ex-wife as his primary next of kin for decision-making. This is a catastrophic failure of the 661 exit strategy. You must meet with an estate planner to draft a new will, a new durable power of attorney, and a new healthcare directive. In 2026, many individuals are moving their assets into a revocable living trust to ensure that their share of the Pacific Northwest real estate market is protected specifically for their heirs, completely bypassing the potential for an ex-spouse to claim a statutory share through a legal loophole. Furthermore, the 2027 financial reset requires a new investment philosophy tailored for a single-income household in an era of 2026 inflation. If you were the spouse who received a cash equalization payment, you are now sitting on a significant amount of liquidity in a volatile market. The 661 method advises against making any major, impulsive purchases for at least 6 months. Instead, you work with a financial advisor to create a laddered investment strategy that accounts for your new tax bracket. In Washington, you must be particularly mindful of the ongoing evolution of state-level capital gains taxes. If you are managing a large portfolio of tech stocks awarded in the divorce, your 2027 strategy should involve a gradual diversification to mitigate the risk of a regional economic downturn. You are no longer investing for a couple. You are investing for your own long-term stability and the legacy you wish to leave. The final secret to turning your 661 experience into the greatest comeback of your life is the professional pivot. We have observed a recurring historical trend where individuals who survive a high-conflict Pacific Northwest divorce emerge with a vastly improved capacity for high-stakes negotiation and project management. The same skills you use to track down RSUs, manage a forensic accountant, and navigate a 10-hour mediation are the exact skills required to excel in the 2026 corporate landscape. Take the example of a professional in the Portland tech scene who, after finalizing their divorce, used their newfound clarity and time to pursue an executive MBA or a specialized certification that they previously lacked the bandwidth for. You are not just a survivor of a legal process. You are a graduate of a masterclass in human psychology and financial forensics. Your comeback is defined by the fact that you now have total control over your most valuable asset, your time. As we conclude this 10-part deep dive into Divorce 661 in the U.S. Pacific Northwest, look back at the roadmap you have built. You started with the fear of the unknown and the complexity of the filing. You moved through the asset hunt, the parenting wars, the financial math, and the high-tech discovery. You survived the mediation pressure cooker and the technical traps of the final decree. Now, standing at the threshold of a new year, you are equipped with a level of data and strategy that most people never acquire. The potential outcomes for your future are no longer dictated by the whims of a judge or the aggression of an ex-spouse. They are dictated by you. But the journey of a 661 graduate never truly ends because the world keeps moving. While you have mastered the mechanics of the divorce itself, a new set of challenges is emerging in the 2027 Pacific Northwest. From the impact of new state-level digital privacy laws on future co-parenting to the radical shifts in the 2027 regional property tax codes, the landscape is already changing. In our upcoming series, we are going to explore the high-stakes world of post-divorce wealth building and the new laws of relocation that every PNW parent needs to know before the next school year begins. You have secured your freedom. Now it is time to build your empire. Stay focused on the data, keep your fortress strong, and we will see you in the next masterclass.